And welcome, Samantha.
Thank you, Jody. Good afternoon, everyone. Thank you so much for joining us today. As Jody mentioned, I will be presenting on the reasons you want to avoid a probate proceeding and sharing some strategies on how to avoid probate. I will also provide specific examples of the common problems that can arise in probate administration matters. So here on the screen is our team at NM Law. Since the group photo was taken, we've added a couple more team members, but it's really our team is one of the things that sets us apart from other law firms who practice in the same area of law. Our attorneys have a wide range of experience, and we utilize our paralegals and legal assistants whenever possible to keep our fees as low as possible for our clients. Our goal is to provide value by solving our clients' matters without incurring too much time and money with creative solution strategies. And our team approach allows us to deliver exceptional and efficient results. Probate proceedings are one of the most avoidable and costly outcomes of not having an estate plan in place, costing Americans about $2 million annually, with 75 of that going to attorneys' fees. Even those who have had access to highly sophisticated legal teams while alive sometimes leave their family to deal with the nightmare of a probate proceeding upon death, as was the case with Prince, Jimi Hendrix, Aretha Franklin, Michael Jackson, and many other celebrities. Before I get too deep into why everyone wants to avoid a probate proceeding, I wanted to start with when a probate proceeding is necessary. So here in the state of California, if somebody passes away having assets outside of a trust, so in their individual name, and these assets, if they have a collective value of more than $166,250, the assets will require a probate proceeding to transfer title from the decedent's name to the decedent's heirs. And if you think about it, it makes sense conceptually speaking, because when a person passes away with assets in their individual name, there's no person or entity or anyone else who can sign transfer documents or a sale document on their behalf. That requires the court to appoint somebody as an administrator of an estate, or if they have a will, an executor of a will, and that person has the authority to sell and distribute assets on behalf of the decedent. So if somebody owns a home in the state of California, it's very likely going to be valued more than $166,250. And this is the collective value of all assets in their individual name. So if somebody has a bank account with $20,000 in it, for example, and an investment account with $150,000 in it at their death, you're going to have to probate both of these accounts. So unless there's another exception, which we always look for before we decide a probate's necessary. So another thing to keep in mind, it's the gross value of all the assets. So a lot of people will come in and they'll tell us, yeah, my house, my parents' house is a $500,000 house, but it has a mortgage against it of $400,000. So, only 100,000 equity. Can we avoid probate? Typically that answer is going to be no. It's the gross value of the asset, and it does not matter what the equity is. So in that example, having that equity of only 100,000, which is below that threshold limit of 166,000, you're still going to require probate for there, even though there's only 100,000 of equity. Retirement accounts such as IRA, 401k, and life insurance policies. Typically, these assets should always avoid a probate as long as a beneficiary or beneficiaries are designated in the plan itself and by the owner of the plan. So these accounts and this policy, a life insurance policy, is typically paid directly to the claimants as long as they are designated as beneficiaries. However, in our experience, retirement accounts and life insurance policies are something that we often see people kind of set up and then forget about. If they left that job, 10 years ago, 15 years ago, they might not even remember that it's necessarily out there. If beneficiaries are not designated, the asset is going to default to the heirs of the decedent, and the account or policy will have to be probated in order to be paid out. This creates quite a problem, because if you do set it and forget it, it's likely to have been invested all those years, and the threshold limit, it's likely going to exceed that threshold limit of 166,250. On many occasions with these type of retirement accounts and life insurance policies, we will see that someone will designate beneficiaries, but then a beneficiary will pass away before the owner of the retirement account or life insurance policy passes away. So if you have these accounts, or if your clients have these accounts, please make sure that they are regularly reviewed to check to see that the beneficiary designation forms are in place and that these assets do not trigger a probate proceeding upon death. One option that we often discuss with our clients with regard to these retirement accounts and 401ks and life insurance policies is that sometimes it makes sense to designate their revocable living trust as a contingent or remainder beneficiary after a spouse, maybe after a spouse and then children second. Maybe you want to designate your trust as your third beneficiary. Although just designating your trust as a beneficiary without seeking legal advice is not advisable, due to a couple tax savings plans that the CPAs will tell you, it's not always a good idea to keep your life insurance or drop the life insurance or retirement account into a trust. So I will pause briefly for questions to ask Jody if we have any questions yet.
I don't see any questions so far in the chat box.
Okay.
If you have questions, please use the chat box.
Thank you. So the reasons why everyone wants to avoid a probate proceeding, for you, for your spouse, for your children, is because of the incredibly long time they take. There's just so many delays, and they're very expensive compared to putting a plan together while you're living with capacity. It takes about 4 months just to get somebody appointed as the administrator of an estate. And then from there, once somebody is appointed, another 8 to 12 months to finish the probate. So during that 8 to 12 months after someone's appointed, they can go ahead and sell assets, but they can't make any distributions. So this is pretty frustrating for somebody, for example, if they're the sole child of a deceased person and the sole heir of that deceased person or beneficiary under a will, even though they are the only person that the money is supposed to go to, they are not allowed, they're actually prohibited under the law to make distributions to themselves after they sell assets until we get a court order. So for an estate with a gross value of about $600,000, this would be, a modest size home here in Orange County, the minimum attorney's fees is going to be $15,000. And the fees are based on the gross value of all the assets of the estate, and they're calculated pursuant to the probate code. There's actually a statutory sort of sliding scale that sets the attorney's fees for us. As I mentioned, it's based on the gross value of all the assets. So even if that estate, the house worth $600,000, say it has a loan against it of $500,000, so there's only $100,000 of equity. Well, the attorney's fees are still based on the gross value of $600,000. And attorney's fees are one of the first things that are going to get paid, actually before some of the creditors, and then before any of the heirs are going to receive any of their inheritance. So in addition to those attorney's fees, which are again set by statute, there are costs and expenses involved in every probate proceeding, which are completely unavoidable. Such of these costs are such as filing fees. The first appearance filing fee for any court petition in the probate court is about $450. Then we have appraisal fees to appraise that house or the business, whatever needs to come through probate has to be appraised by the probate referee and the administrator of the estate for some assets. And there's also a newspaper publication fee. So, you have to publish notice in a local newspaper in the county where the decedent passed away. And the minimum fees for a probate from start to finish, I would estimate are about $2,000 to $4,000. And that's on the lower side as the estate gets larger. If we have 6 properties or a $4 million estate, for example, those fees are just going to tick up because they're all based on, how many different filings you have to do. And with each property you're selling or with each asset you're dealing with, you have to do more filings. Another reason why you want to avoid a probate proceeding is that the administrator of the estate is required to give notice to all creditors. So I just referenced the publication on local newspaper. That is one way creditors receive notice. Another way is that once an administrator is appointed by the court, they are required to mail directly to all known or suspected creditors a notice that says, you have 4 months basically to make a claim in the estate. So creditors will either exercise their right to make a claim. Sometimes they don't. And we never really pay claims that are not filed unless they're like a secured creditor on an asset that the administrator wants to keep or something like that. But typically we will only advise our clients to pay creditors that make claims in the estate. They have to file and serve them on us. So creditors get paid first. There's actually a statutory priority set forth in the probate code that gives the priority for which creditors get paid. The IRS and the Franchise Tax Board of California, the government entities are going to get paid first. The attorney and the administrator do get paid first as well before general creditors. Secured creditors, if you have a mortgage on a house, of course, that creditor is going to be paid. The mortgage company will be paid when the asset's sold. And then the general creditors or unsecured creditors, such as credit card companies, medical bills, things like that, those are all paid last. So if there's not enough money, not all the creditors will get paid. But the flip side of that coin and the downside would be that if there's so many creditors and creditor claims and other expenses of administration before the creditors are paid, there is a chance, and it has happened before, where the heirs of the estate don't get any inheritance. And it's a pretty sad situation that we always try to avoid. But, when you're stuck in the probate court, you don't really have the ability to deviate from those statutory requirements. And you have to just go through the steps of a standard probate proceeding. I will again pause to just check if we have any other questions.
There aren't any questions at this time, Samantha.
Thank you. And we will move into specific case examples of problems that commonly arise in probate proceeding. So one very popular one, we oftentimes have to probate a business because the ownership interest of that business has not been assigned or transferred to the trust. The trust is not the owner, or the business owner just simply doesn't have a trust in place and no succession plan under the corporate documents. So this can cause some expenses this can cause some problems because, even though it's not, advisable or best practice, oftentimes business owners will run personal expenses through their business. So, what they may deem as a business expense, the IRS or the Franchise Tax Board may not necessarily agree. This causes problems because, as I previously mentioned, the administrator of the estate has to give notice to the IRS and the Franchise Tax Board. The IRS has up to 6 years to audit a deceased person's tax returns. And if errors or inconsistencies are found, prior tax returns oftentimes have to be amended and refiled that way. So although it's not advisable, many business owners will run these expenses through their business and it saves on income taxes while they're living. But, if you're going to do that, then you have to have a trust in place to make sure that, you're not going to get caught on the back end, so to speak. Oftentimes too, the deceased business owner has not done their final tax return, and which then the administrator of the estate needs to do. For example, if somebody passes away in the middle of the year, in middle of 2021, the administrator of the estate is going to have to do that person, 6 months of income tax reporting for the deceased person and the business in this case. So, I have worked on a probate recently where the decedent did not file the last 3 years of his business tax returns. And it turned out that the IRS had a claim of over $350,000 against the estate. So that quickly ate up a lot of the inheritance that was supposed to go to the deceased heirs. So this is one of the reasons why it's really advisable for business owners to always assign their business ownership to their trust. First and foremost, put the trust in place. And then second, we do a series of assignments, for corporate shares or membership, LLC interest into the trust document itself. We also help with business succession planning and business transactional law. So let us know if you ever run into any questions about those things. Another really common problem is when we have these unknown heirs come forward. In all probate proceedings, the administrator of the estate is required to publish notice in a local newspaper. As I previously touched upon, it's to allow creditors to come forward, but also heirs to sort of, I guess, be reading the newspaper and see that, their cousin or their uncle's estate's being probated, and to, contact that attorney or file something, a notice in the court, to be included as an heir. So we have a probate right now where we initially believed that the decedent had 5 second cousins, and we filed our paperwork on that belief. And then a couple after the newspaper publication was made, 8 additional second cousins came forward, and they all have a right to be included as far as we know. So this result can be avoided if the decedent had a will. A will not keep you out of the probate court, but what it does is it allows you to deviate from the default rules under the California Probate Code. If somebody passes away with a spouse and children, those people are the deceased person's heirs. If the deceased person does not have a spouse or children, then it goes to parents and then siblings and so on and so forth. So having a will, again, will not keep you out of probate court, but it's better than not having anything at all. The only way to stay out of the probate court completely is just to have a trust, and you can avoid that situation where everyone comes out of the woodworks to try to be included. Another business example that I've seen lately is a sole proprietor business owner. A sole proprietor is not a separate a sole proprietorship is not a separate legal entity. It's simply just one person doing business for themselves and with themselves. And that one person is personally responsible for the business debts. When a sole proprietor passes away without having a trust, there is no other person who can continue the business. So all business activity must stop, the bank accounts are frozen, and nobody can get paid, and no business can really continue until an administrator of the estate is appointed by the court. As I shared a little bit earlier, it takes about 4 months to get somebody appointed by the court as the administrator of the estate, from filing to the hearing date. Sometimes we can avoid that 4-month delay and get somebody appointed within a couple of days if we have ex parte or emergency circumstances. And, we always look to see if we have those, such as, if there's going to be damage to the business or damage to the estate, if the business can't run. We can oftentimes find some sort of exigent circumstance, but not in every case. And the court has to agree it's an exigency. I've had experiences sometimes where a notice of default's been recorded. So we're facing a foreclosure of an estate property, and we asked the court for a exigent, an ex parte order appointing somebody, and the court didn't agree that was urgent enough. And they said, why don't you come back once a notice of sale has been recorded? So we thankfully got our administrator appointed before the notice of sale was recorded. But again, the court just has to agree that it's an emergency enough. Again, if you have a sole proprietor, if you know somebody who is a sole proprietor, they can avoid a probate proceeding by incorporating the business and then owning the business ownership interest in a trust. So if it's a corporation, it's going to be corporate shares. If it's an LLC, it's going to be a membership interest. Any questions right now, Jody?
I don't see any, Samantha.
Thank you. Okay, the next examples or series of examples is when the decedent owned real estate. I will tell you that is the most common reason why somebody will have to do a probate. A home value is going to exceed that threshold limit. And it's either a business or a real estate parcel that we're typically probating. So if a decedent owns real estate in their name alone and not in a trust, the delay of a probate proceeding can cause some really serious problems. One of them is squatters. So squatters is basically a trespasser who enters a property with an intent to remain or take up residence there. And we've had problems with squatters in some of our probates where, because the property, when a decedent passes away, will typically have to sit vacant because there's nobody with the, with the court authority to enter the property or to do any sort of dealings with the property. Even if there were squatters there before, a family member started the probate process, they cannot do anything legally speaking until they're appointed by the court as the administrator of the estate. So once an administrator is appointed, they can initiate eviction proceedings or unlawful detainer proceedings. And that's the fun part about probates is it does cross over a lot of different areas of law. So sometimes we're doing quiet title actions, sometimes we're doing unlawful detainer actions. So that's probably the only fun part about probate, but it's only fun for the attorney and no fun for the administrator of the estate who has to, not only deal with the probate, maybe not only deal with the sale of a business or sale of a house, but also has to be in the civil court, trying to get some squatters out of the property before they can sell it. So having, just to look at the flip side of the squatter's coin, and if a house is held in a trust, the successor trustee of that trust just sort of seamlessly floats to the top of that management totem pole, and they have an immediate right to take possession of the property. So they don't have to wait for the court and the inherent delays in a court to be able to take possession. One of our probate properties, to go to the next example of fire, one of our probates, the squatters actually started a fire in the property, which burned the property so badly that we ended up having to do a short sale of just the land, not even including the structure, back to the bank. And that was because the fire burned so much of the structure. So instead of the heirs receiving any inheritance and all, there was no money to be distributed at the end of this probate proceeding that involved the fire. And we did the best we could to get somebody appointed right away. But again, there's just so many inherent delays that it's not easy to do in the probate court. Another example that has come up more recently is reverse mortgages. It's a really common strategy to get a reverse mortgage for an elderly person who wants to stay in their home. It's not right for everyone, but it is a really good strategy for some people. And the problem with a reverse mortgage is that when the borrower, the property owner, passes away, the bank will call the mortgage due. And with every day that passes, the estate is losing hundreds of dollars of equity until an administrator can be appointed. And then they want to sell the property as fast as possible to preserve as much equity as possible. Sometimes, the family might want to keep the home, and that presents a really big problem with a reverse mortgage that's involved in a probate, because you have to try to refinance the house before you have a court order, saying you're able to distribute title to the home. So it's sort of putting the cart before the horse, chicken before the egg question as to, how are we going to allow somebody to refinance the home when, we have to ask for the court to first distribute the home. Oftentimes that'll involve, heirs having to advance money into the estate to pay attorney's fees, creditors, and costs and expenses before we can get that court order to allow a refinance of that reverse mortgage. And again, just to look at the flip side with this example, if you have the house in trust with a reverse mortgage against it, the successor trustee can just seamlessly float to the top, ask the beneficiaries of the trust, do we want to keep this house? Do we want to sell this house? The trustee makes a decision, and the reverse mortgage is paid, preserving as much equity as possible in the home. And it looks like I have one question. I will answer this question before moving on. And the question is, I hear advertising about locking title. Do you know anything about that? Or if so, does that affect probate or the trust? I'm not quite sure what locking title would mean. Perhaps that's like recording a lease pendants or putting and I'm not quite sure if the person who asked the question could provide a little bit more details about what they refer to by locking title. If you know, then I'd be happy to answer that one. But I have not heard that term and would need to look that one up. So moving on to, so the strategies to avoid probate are sort of different for every person and every asset, or there are some differences or variables that would affect, our decisions and our advice to our clients. But the best way to avoid a probate upon passing is to have an estate plan that includes a revocable trust. And then you want to transfer your assets into the trust, and that's the best way to avoid a probate proceeding. If you know somebody who does not have an estate plan or trust, please refer them to our firm so we can help them get a plan together. They always have a right to put a plan together as long as they have capacity, so you never want to wait until you're too old or too infirm to put that plan together, because as we all get older, we're all going to start to experience signs of diminished capacity or short-term memory loss, and that affects your ability to be able to put that plan together. A comprehensive estate plan will typically include, the documents that I've listed here. A revocable trust, pour-over wills, powers of attorney are very important, and healthcare directives. Anyone over the age of 18 should always have at least a will, a power of attorney, and a healthcare directive. And then as you start to gain more assets and collect more assets throughout your lifetime, then a trust is going to be necessary as you get to that $100,000, $120,000 threshold. Then the transfer documents that we include and prepare are grant deeds for real property to transfer them into the trust, assignments of personal property and business ownership interests, and things of that nature. We also help our clients review and fill out or complete the beneficiary designation forms for that life insurance plan or policy, 401k, Roth IRA. Really important to make sure that those documents are filled out correctly to avoid a probate of those, more high net worth assets that tend to grow over time. So when someone contacts us about a potential probate, we always start by first analyzing all of the assets to determine if there's any way we could avoid a probate. Because they are so costly and so time consuming, we try to sort of find some assets that we can potentially transfer without involving in a probate, and to get the sort of gross collective assets down lower than that threshold. So if we determine a probate is necessary, it is best to file the paperwork as soon as possible after death to avoid the common situation where trespassers or squatters enter to the decedent's property to take up residence, or the unfortunate situation that can result when business employees are not being paid because the business accounts are frozen. If there are exigent or emergency circumstances involved, which I touched upon earlier, we can typically get an executor appointed as a special administrator or on an ex parte basis, and that we can typically do within only a few days of filing. So we offer a free consultation to determine, if and how we can help. We like to first review the facts and documents to determine if it's a good fit for us and if it's a good fit for the client. And, we typically need a lot of information in order to even decide if we can represent the person. So the purpose of the free consultation is to determine if and how we can help. So please do not hesitate to reach out to me or another team member at our firm if you or somebody you know has questions about how to put a plan together to avoid a probate proceeding. And I have another question here. Thank you for putting, Jody put my contact information in the chat box. If you want to copy and paste it, it's there for you. And the question I have here is, do cash assets need to reside or be held in the actual trust account? For example, cash left in a regular checking account, will that be susceptible to probate simply because it's not in the trust or bank account? That's a really good question. Through our planning meetings with our clients, we kind of go through, okay, what assets do you have? These assets we advise putting in your trust, and these assets are sort of optional. And then we might have another group that says, these assets you want to avoid putting in your trust. That's typically, retirement accounts and life insurance policies, anything with that beneficiary designation form. We always want to see if there's a way to avoid putting it in the trust. But for those optional assets, like in this question, it's just a bank account. Maybe you have a home, your home's in your trust. Say you have an investment account, your investment account's in your trust, your business assets are in your trust, but then you have one sort of checking account that's not in your trust. It's okay to stay outside of your trust as long as all of your assets outside of trust do not exceed that threshold limit of 166,250. And also you want to always make sure you have a pour of a will and a general assignment of personal property, because your bank account and any cash is considered personal property, just as your furniture would be, and your household items is all personal property. And you want to have a general assignment of your personal property into your trust and a pour of a will. That will help us avoid probate. Say for example, that account were to grow as the person is getting older and starts to have diminished capacity, and then they can no longer transfer it into the trust. We might, oftentimes too, if that were to be the case, we could represent the successor trustee after them, so to activate their powers under the incapacity language of the trust and help a successor trustee, help their parent. Maybe it's a parent with dementia or Alzheimer's and they have that one checking account. So my answer, it depends on a couple different variables, but we always do look at each and every account and each and every type of asset to make that determination with our clients. Any other questions? Well, thank you for joining us all this afternoon. We really appreciate your time and your participation. I'll turn it back to Jody.
Thank you everyone for joining us. We will send a recording of this webinar for your future reference. And just in case you might know someone else who would be interested in this information. Also, be on the lookout for our next invitation to our next webinar by Noelle Minto. She'll be our presenter. And it's going to be on the topic of using your trust to successfully launch your children into adulthood. So that should be really interesting. Thanks again for joining us. Wishing you a wonderful day.